This one actually is relevant, so if you want to learn more, you can ask about it later. But I've never actually had to research I've never had to actually read a case to vote on a constitutional amendment. This one I actually did my homework on. Fascinating issue. Okay, David.
No, does the Attorney General get to file a brief with
Yes.
the Supreme Court?
Yes. So the Attorney General generally has the ability to intervene in virtually any case, and even if they can't intervene, they file what's called an amicus brief, friend of the court brief. The problem was in the case I mentioned, the divorce case, no notice was given. So by the time the AG found out about it, it was already too late to intervene. So this is saying before the court rules that something's unconstitutional, 45 days notice has to be given to the government so that the AG can intervene. There's a similar rule in the federal system where generally in any federal case where the constitutionality of a federal statute is at issue, the U.S. government usually intervenes or files an amicus brief or something to defend their own laws. Because if you think about it, you had a couple, right? A husband, I think it was a wife and a wife, right? Neither of them wanted this statute to be on the books. So they're basically suing each other for a divorce, but they want the statute to be struck down in the meantime. So no one actually defended the constitutionality of the statute. What this amendment would do is make sure someone can actually go to court and defend it. It's a weird thing when you have a court decision and both parties agree on it. Judges aren't typically in a good spot to spot out flaws in an argument. No one can challenge it. So what invariably ends up happening is they'll appoint a third party to argue as amicus. This even happens in the Supreme Court of the United States, where sometimes there'll be conviction and the government doesn't want to defend the judgment below. The Supreme Court will appoint basically a devil's advocate to argue on behalf of the government, even though the government won't take that position. So it's a weird spot. Anyway, go vote. Always vote. Haven't missed an election since I was 18. Not yet.
Even school board?
I vote for everything, yeah. Even
utilities?
When I lived in Pennsylvania, I voted for coroner. You can actually vote for coroner. It's on the ballot. I don't know. I think I left it blank. I didn't really know who to vote for caring for that. Yeah, Bradley.
Is that out of principle or you actually care?
The principle is I care. Yeah. I know it's irrelevant, but it's important to me. But you should all vote. You're informed citizens. And George Springer is not on the ballot. You can't vote for him again. But I think you can write him in, I suppose, for school board. Okay. Any other questions before we get started? All right. So let me turn this off. Wow, a lot of people stayed up late last night, 25 out. I see a lot of orange. Let's see if actually not that much orange. Okay, I see a little bit of orange. Let's start with this. Let's start with this question. Okay, we're going to spend a lot of time in Penn Cole and Penn Central today. Try not to confuse them. They're very similar names: Penn Cole, Penn Central, right? They're both Penn C. So try to keep them separate. So this is a question I want to start with. Let's see how this one goes. Okay, so the landmark. Oops. Sorry, covered the question. The landmark law that was at issue in Penn Central extinguished all of the air rights above Grand Central Station. That's your question for today. For all 20 minutes in the class. The landmark law at issue in Penn Central extinguished all the air rights above Grand Central Station. All right, so let me show you a picture before I start calling on people so you get a sense of what we're talking about. Has anyone ever been to Grand Central Station? Okay, a couple of you. So it's a humongous train station in Midtown Manhattan. I'll show you some pictures. So this is like the front of it, and you can see there's like a huge tower right behind it. It has these. I took these pictures myself. That's why they're so blurry. This is funny. I actually had some pictures on my blog some years ago that I didn't take. I borrowed, and I got like a takedown notice. So I said, screw it. I just went and took pictures myself. But they have this beautiful map of the constellations. But the most striking feature about Grand Central Station is when you're coming down this main street, you see these huge towers behind it. You can see it better in this picture. This is a very iconic photo. But it's very low. So imagine you have, nothing, and then it shoots right up. So what happened before is this humongous structure was built behind Grand Central Station. It was a very high tower. So then a couple years later, they said, okay, we want to build a high tower here also and change the face of this train station. So I have in the book the various blueprints. The blueprints are supposed to look. This one I'll show you. So you're driving in the street, and basically you see it's all small buildings except for like this one, and then you get to the Empire State Building down the road, right? So you have this gorgeous view of downtown. This one was built, and they tried to build a tower here. And that's when the freak out happened. Okay, these are the various blueprints. So under one blueprint, they just wanted to basically literally lob a tower on top of the old train station, like just plop it on top. And under the other one, they would more or less take out the entire facade, the entire front of it, and just make it like these pillars to put on top of it. So that was what the thing appeared like. They had 50-story tower on top. But my question for you is a lot simpler. My question concerns the extinguishing of the air rights. Okay? True or false? All right. Where are we? Valerie, what's your answer here?
I put false.
Okay, why do you say false?
Because it didn't necessarily extinguish all of their rights, it's just that structure they wanted to build.
Well, the question is, are they extinguishing all the air rights above Grand Central Station? That's the question, right? So are the remaining air rights to build above it?
Yes.
How so?
Well, they didn't say you can't build anything at all, just you can't build what you wanted to build. That 50 story.
Okay, Natalie, what's your answer there?
I put false as well.
Okay, tell me why.
For the same reason, it was that specific structure that they didn't like, and I think the law in the case was more about like keeping the aesthetics of the building the same, the outside of it. So.
Okay, so Phil, let me just change the facts a little bit. Let's say instead of building a 50-story tower, they tried to build a 2-story tower, maybe even a 1-story tower on top of it, right? And then the city denied that also. Would that change your answer here?
Not necessarily, because I think it would depend on what the tower looked like and how much it like changed the appearance and I guess function maybe of the.
So let's use this example, right? So, right, train station is the same, and then you just add one, right? 1 story like this. They need some more office space, and they don't change the facade at all. And the city says, no, you cannot do that at all. Does that change your answer here?
Well, it certainly makes a stronger argument for the other answer, but I still think that there's, as long as they don't definitively say that no, you can't build anything, I think there could still be leeway to.
Okay, well, Simone, I'll give you Philip's question, right? What if the law said you can't build anything over, let's say it was 10 stories, I'm making it up. Let's say you can't build anything higher than that. That's a law. You cannot build higher than 10 stories, period, anywhere in Manhattan. If you've already built it, fine, keep it, but you can't build anything taller than that high, 10 stories. That's the law.
I mean, if they wanted to build it right there, like they want to build it right there, so essentially I feel like that's kind of like they're taking this.
So you think if the law said you can't build anything in Manhattan taller than 10 stories, that would be a taking?
Yeah, because if they wanted to build it somewhere else, they would build it somewhere else.
So let me ask you a follow-up. Is there a difference between putting a blanket prohibition on building above 10 stories in the entire city versus in this case on a case-by-case basis picking out this? Okay, tell me what's the difference?
Because if you do a blanket, it's not like you're just distinguishing like against one person. It's more so on everybody. So I guess technically it would change it if it was over the whole city of Manhattan.
Okay. Okay, but Chess, let's say this one, right? Let's say the planning board came back and said, Grand Central Station, we're making a ruling now for you and you alone. You cannot build anything on top of your tower. That's it. However tall it is, that's it. You're done. Does that extinguish all the air rights in that case?
When they tell them that they can't
You can't build anything. You cannot go 1 inch higher.
I believe that does.
Okay.
There's many options.
So does that necessarily make it a taking?
It doesn't necessarily make it taking. I think the strong argument is if the government actually physically intruded or into that.
Well, if they physically intrude, that's Loretto, right?
Yeah.
If I'm asking that, the planning commission comes back and says, you cannot go 1 inch, not 1 inch taller. Nothing you can do.
Yeah.
Is that necessarily a taking? 100%?
Not necessarily. I know that case talked about, because they're already in existence compared to a company that wanted to create and that law was there or that affects their financial.
So the fact is, they're saying, look, you can keep your train station running, you just can't expand it. You're making your profit, you can't do new stuff, right? And you think that might not be a taking?
Might not be.
Jackson, what do you think? They say you cannot build 1 inch taller, not a single inch. Is that going to be always taken?
Is it Jackson?
I'm sorry, what's your name?
Walker?
I think Jackson sits from my other class today.
No worries.
You bring your name tag, I'll help.
So they
That's right, I think I have
directly,
Jackson somewhere in the other class, I apologize.
the court directly addressed that in Penn Central, and they said even if they weren't able to build something above Penn Central, it's like quote unquote, it's literally not accurate to say that they've been denied all of those pre-existing air rights, because like in that case they were able to, it was like transfer those rights to like other buildings that they own, correct?
Oh, good. But let's put aside the transfer rights. We'll talk about that a little bit later. I just want to talk about now the question I asked Chester, I'm asking you also. Is it going to necessarily be a taking if the city says you can't build 1 inch taller and you can't transfer those rights anywhere else? Is that going to necessarily be a taking? 100% certainty.
No, because that still hasn't destroyed all of your rights.
All. What else do they have aside from the air rights? What do they still have remaining? You said it already, but just repeat it. What do they have beyond the air rights?
The pre-existing
The train station, right? They still have the train station. So this is the reason why Penn Central drives students batty, and the reason why I framed the question the way I did. Whether or not they have these transfer credits, we'll get to these transfer credits in a minute, right? And whether or not the commission would have approved a shorter construction, I don't think they would have, right? I don't think they would have gotten anything. It doesn't matter, because we look at, under Penn Central, the entire parcel, right? You don't just consider the air rights when you're looking at the question of taking. You consider from the ground up. And because under Penn Central, they still have value from their investments. They can still run the train station, they have their office space, shopping, right? Because they're still going to have value there, the mere fact that the air rights were extinguished, I think they probably were here, is irrelevant, right? Again, under Penn Central, you look at the parcel as a whole, which is the phrase, right? You look at not just the air rights by itself, but the building and the air rights above it. And because they can still get a return on their prior investments, right? They invest in building a train station, that's still profitable. Under the sort of regime of Penn Central, the government can prevail. Does not pay compensation. It's under the police power. Right? So applying Penn Central is a lot harder than the example I gave you. But if you can remember, you don't separate the air rights from the surface rights. You consider the parcel as a whole. Now, someone's going to ask you, wait a minute, Josh, what was the Penn Coal case, right? Josh, what was the Penn Coal case? We're going to do that one first, aren't we? We'll do it first, I promise. But in that case, you had digging underground, right? And the stuff above ground was fine. Because the digging below ground, that was an issue. What you have to understand is, in some respects, Justice Brandeis's dissent in Penn Coal won the day. Never overturned. Please don't tell me that Justice Holmes' opinion was overturned. But there's a portion of Justice Brandeis's dissent, which we'll get to in a bit, where he speaks you have to look at the parcel as a whole, where there's still other profitable uses of this land. That's your analysis. So I'm going to bring you back to high school algebra. Oh, right. Remember this one. Actually, when I do it like this, it's even worse. You have the numerator and the denominator, right? Guys, you remember this? The fraction. The number on the top of the line and the number on the bottom of the line. What's that? You lost it. I swear, you guys. I swear. You need to actually know this, I promise. When Justice Busby's here next week, he'll mention the denominator, so I'm actually saving him the pain of embarrassing you. So you have a fraction, right? 1/2 is 1/2. Okay? What is the correct denominator when we're talking about takings cases? Are we only looking at the air rights, or are we looking at the parcel of the whole? Right? So let's say, we're only looking at the air rights. Right? So what's taken away? 100%. Right? They're killing all of your air rights. And what's the relevant metric? Only the air rights. If you have 100 over 100, it's basically 1. That's a taking. Okay? But let's say you're looking at the surface and air rights. So what's being removed? Half. So you have 50, and you still have the denominator of 100. Right? The entire parcel. So now you're at 1/2. So here you're losing all of your value, and here you're losing only half of your value. Depending what your numerator is, and depending what your denominator is, the answer comes out very differently. Everyone understand this? I'll say this again. If you only look at the air rights, and they're taking away all of your air rights, you lose all of your value, right? If you go back to our building, if all we're considering is what comes above the building, you're losing all that. And if you lose all of that, you're going to get your takings claim. But Penn Central says, how much money are you actually losing? So if you only consider the stuff above, right, and not stuff below, you're losing maybe 50% of what you got. So you only have half of a loss. Okay? I know this sounds a little bit confusing. I think it'll make more sense as we get through the class today. But keep in mind that under Penn Central, you cannot separate the air rights from the surface rights. You have to look at the parcel as a whole. Okay. Yes, sir, Tyler.
They referenced a lot to I forgot the name of the case, but it was talking about the airplanes going over.
Yeah, Cosby, yeah.
So is the difference because they were looking at the air rights were in direct correlation with the rights of the rest of the property?
So everyone loves the airplane case, right? So let me just give you the background. So you had a farmer, right? Who had I think it was a chicken farm, right? And he had a chicken farm. And he would complain because these new thing called airplanes, they were fairly new back then, would be flying over his property and would scare his chickens. And he actually wrote a takings claim. So Tyler, here's the short answer to that case. I don't think that's good law anymore. Penn Central tried really hard to reconcile all these various cases, but it kind of threw the chicken case out the coop. So, I'm sorry. I think it's difficult to reconcile, but I think at least Penn Central tried saying that was a permanent flight path, there's always something over it. You basically lost the ability to touch the air rights altogether. But you're going to say, what about Penn Central?
Well, is it kind of saying they were physically intruding on those rights with planes as opposed to they were giving prohibition to Penn Central to build?
What's the difference though? He can't use his air rights.
Well, because it was a restriction and not a taking.
So what's the most fundamental stick in the bundle? Which one is that?
Right to exclude.
So whether you're excluding an airplane or whether you're saying you can't build here, that same stick is being diminished.
But it's not like the same as Loretto.
Well, an airplane is not a permanent physical occupation, right? The airplane is there for a few seconds and flies away, and then maybe an hour later another plane comes by. I think that's still temporary. Okay. And I think you're still in Penn Central land. I don't want you to. I like Cosby. It's a good case. That's CAUSBY, not like Bill, but like CAUSBY. But I like that case, but I don't think it has much
So don't use it on the file.
I wouldn't use it in a brief either, to be frank, not just for my class. I wouldn't put it in a brief. Okay. All right. Question before we get started. All right. Let's go on to the case. See what people put. Whoa! Look at that, 100%. Good job.
Right or wrong?
I think that's right. Did you guys change your answers?
Yeah.
Oh, are people switching their answers? Do I have to stop the running? Is that a thing now? I'm lucky I don't grade these things. Okay. All right, so let's go on to the first case. All right, I think, Yusuf, I think you're next, my friend. All right, you want to just give us the general facts in Penn, Colby, Mayhem, please?
Yeah, so Penn Cole conveyed some land to Mahone, and in that transfer, they retained the right to mine underneath the land.
Very good.
And Mahone took the land, understanding that they're taking the land with all the risks associated with mining underneath their land. Soon after, Pennsylvania enacted a statute that said that any type of mining underneath the land that would affect the surface land would is not allowed. And so Mahone sued to stop an injunction and stop them from mining underneath the land.
Very good. So, Yusuf, what's subsidence? What's this phrase? Subsidence.
So
Subsidence. Here. Subsidence. What's subsidence? Paul, you know what that is? Yeah, cave-in, exactly. Look up words that you know what they are, always. But thank you, that was a very good recitation. So here are some pictures. This is fairly obvious, but you never thought about it. When you dig underneath something, the stuff on top falls, right? If you're into the beach, right, you built like a sand castle, and then you start digging under the castle, the entire thing caves in. Right, that's what subsidence is. And I have some pictures here showing what happens. Particularly with minerals, coal, whatever you have to dig these things called columns, which are basically very deep cuts into the ground. And imagine if like your house is on top of a coal mine, and then they're digging, and there's a cave-in. Okay, your house is now underwater, underground, right? They have what's called a sinkhole, right? The entire house basically falls to the ground. This isn't only with minerals, also with gas and liquids as well, because you have these huge cavities in the ground where if the stuff holding up the dirt becomes too low of a level, the dirt just caves in. So Pennsylvania passed a law that would seem to make some sense. That said, you can't mine in any way that results in subsidence. That's where the ground caves in. It makes sense. The problem is, this coal company, the Penn Coal Company, had been given a license to mine. So there were actually a threshold issue that Holmes mentioned briefly and ignored, which is the contracts clause. The Constitution has a contracts clause which says that the estates cannot violate or breach contracts. So in a sense, this was a breach of a contract, right? They have a right to mine, and this statute comes and says, no, you can't mine. Holmes mentioned it briefly, but he resolves it under the takings clause. And he argued, does this statute amount to a taking? Now, to use the example I left in class, this was not a case where the government was suing the coal company, right? This was a case where the coal company was being sued by a homeowner. And the case turned on the constitutionality of a statute, right? Because if this statute amounts to a taking and there's no compensation, the coal company wins. But here I suspect, and I think I read it somewhere, that the government was allowed to participate in the case. Because again, generally, you don't want to strike down a law when the government doesn't have a chance to participate. It's very unseemly to do so. Why this case, though, drives people crazy, though, is it's not very clear. People rolling their eyes, I can see. Jonathan, why is this case perhaps not so clear? What's Justice Holmes' test, we can call it that, to determine when these sorts of regulations are part of the police power and when these sorts of regulations fall under the takings power?
I think particularly in this case, it's, well, because it's between just the landowner, it's just one private individual. So it's just kind of, it's not really affecting the public as a whole because it's just with one person.
Is this like spot zoning, to borrow from something we talked about elsewhere? Is this a law that was passed only for the for this property, Mayhouse property?
No, it is, but it's just kind of just affecting that property well in that case.
But doesn't it improve the community as a whole? Do we really want to live in a state where like the Grand Rambley falls underneath us?
No. Not particularly. I mean, it would be protecting, well, I think it's kind of more the dissent where he's kind of defending it. Where he's saying it really is a exercise of the police power, where it is the majority.
So Essay, let me jump to you. Let's just stick with the majority. We'll get to Brandeis a little bit later. So, how does Justice Holmes distinguish between when something's in the police power versus when something moves over to takings? This is our question for the last month, right? Is it police power or is it takings? If it's police power, it's free. If it's takings, you got to pay compensation. So, how does Holmes try to distinguish the two?
He says one factor for consideration is this is a hard word to pronounce, but diminution.
Diminution in value, very good. That's exactly right.
Quote, when it reaches a certain magnitude, in most, if not all cases, there must be an exercise of the eminent domain of compensation to sustain that. So when they divided the rights between the surface rights to the plaintiff and the whole rights to the company, but they're not allowed to mine toward the whole. They said, what's the point? So the value divided is a factor for consideration.
Very good. So, Essay said the test exactly correct. It's referred to the diminution in value test. Okay? The diminution in value. It is a hard word to say. I'll give you that. I always stumble over it. What does it mean, diminution in value? Well, if the government action results in the value of the land being diminished, right? If the government action results in the value of the land being diminished too much, it's a taking. I call this the Goldilocks rule. It's not too hot, right? Not too cold, just right. Now, Virginia, does Holmes give us any indication whatsoever when it goes too far, when some government regulation goes too far to diminish the value and then it jumps over from a police power or taking tax?
Not really, just as a professional degree.
Yeah, right?
It doesn't,
Yeah.
say, oh, you have to lose, 80% of your value or anything like that.
Exactly. Right. So this case drives students nuts because, like, what's the test, right? It goes too far, right? I mean, that's literally, I think I'm quoting verbatim. I think that's the literal verbatim quote, right? It goes too far. That's your test. So I think Justice Holmes is the most overrated justice after John Marshall. Things like this. I believe that sincerely. You get on my college. Watch my lecture on Marbury if you want to know the background. It's wrong. Wrongly decided, completely. But the general rule, at least, is that while property may be regulated to a certain extent, if regulation goes too far, that's the test, goes too far, it'll be recognized as a taking. And at that point, he says this is a case-by-case basis. Now, he doesn't draw the line, right? He doesn't give you any sort of line. But, Lauren, in this case, is a line crossed? In this case? Well, the majority.
Yeah.
Well,
the majority says that, they said that they never had the right at all. They never had the rights to the underground anyway, so.
Who's they? I'm not,
The landowner, the home.
Right, so the plaintiff was on the top, right?
Right.
The defendant was on the bottom.
Right.
We're asking here, does this regulation go too far in diminishing the value of the coal owner's mine?
Well, it says here that we cannot see the fact that the risk has become a danger, so I would assume that they're saying no.
You're answering my next question. You're exactly right. My threshold question is, does this regulation go too far in diminishing the value of the coal mine underneath? You're answering my very next question.
Oh, then for the coal mine, yes.
Does it extinguish all of his rights to mine?
not all of it, but the good portion of it, yes.
Okay, so you're giving me exactly the right answer, okay? It goes too far, right? Whatever the line is, it goes too far. How do you know that? Because Holmes ruled the coal company, right? So Lauren's right. It goes too far. But it didn't diminish all of their rights. Why? Because they can mine over there and they can mine over there. They just can't mine in the place where there will be subsidence, right? If there's nothing built on top, there's not really a concern. So in other places where subsidence is not a risk, they can continue mining. So this is like saying, well, you can't build a 50-story tower on top, but you can build a 5-story tower on top. They still have other ability to mine elsewhere within this lot. And this is this concept I referenced earlier, the parcel as a whole. Right? The parcel as a whole. You have to look at the entirety of the parcel, all Blackacre, not just this one spot. But however much was ruined here by the subsidence, however much land, for Holmes that went too far. That crossed the line. Okay. Now, Lauren, I'm going to go to Justin for your next point. Justin, does this law seem like an exercise of the police power to you?
Yeah.
What?
I mean, I feel like because they have a right to, look like what we talked about earlier in the cases, they have a right to create ordinances and laws that help protect the public at large and the public good. If the mining under the streets and things like that are going to make it positively impact people in the city, then I think it's within their power.
So, if this is something that's benefiting everyone, right? Why doesn't that police power outweigh whatever minimal cost is incurred by the coal company?
Say it again?
If this is a law that benefits the entire community, that is when you're just driving down the street, you don't want the ground to cave underneath you, right? Why doesn't that police power interest outweigh the loss of profits of these coal companies?
Because you still have to look at they have a right to mine, and if they've already contracted to mine somewhere, they have the right to do that. You're taking their right away, like taking bundles or stick away or whatnot.
Okay. All right. So I think the two of you are basically on the right track. The difficulty of the Holmes opinion is he doesn't explain why this one goes too far, right? He just says it does. And his denominator, right, the land he's considering, is basically just a land where he can't mine. Like, let's say he owned, 100 acres and he can't mine on 5 of those acres, right? The denominator there is the 5 acres he cannot mine. Like, everyone understand that point? What's going too far is not all of the coal company's ownership. It's only where the risk of subsidence exists. Because it might be possible that in other places he could buy the surface rights. And if he buys the surface rights, there's no problem with digging because there's nothing to subside. Yes, sir, Chester.
So would the denominator change if there wasn't a contract?
Let me answer your question this way. So let's just say that I'll make it easy. There are 100 acres, right? And there are 5 acres at risk of subsidence. Easy numbers, right? So under the majority approach, your denominator and numerator are the same. It's 5 out of 5. You can't mine in 5, and all you're looking at is 5. Therefore, your loss is 100, right? Your loss is 100%. The dissent, though, looks a little bit differently. They say, look, you can't mine on 5, but you still have about 95 other acres, right? So I'm not very good at math, but you have one of 20-something? Yeah. I never tried doing math up here because I always screw it up. People yell at me. So it's less than 100%. That's supposed to be no black and wrong. So I stopped when I do the class in wills and trusts. Remember the first derbies, right? You try to divide up. Student says, "What about this one?" No, I'm not doing it. No. So, but it's Chester. To answer your question, the majority approach. They look. You can't mine on 5, and all we're looking at is 5 acres you can't mine on, right?
So they're not even considering the contract.
Yeah. Putting aside the contract, right? But the dissent is, look, the contract was for 100 acres, right? The dissent brings the contract into it. The dissent says, look, you have a lease for 100 acres to mine. The subsidence is only about 5 acres worth. So you still have 95 other acres that you can go mining on, and you still have a very good profit return. So depending how you skew the numerator and the denominator, you get very different answers. Yes, ma'am.
I remember reading somewhere they were saying something about 100 feet underneath the home. I'm confused by the whole case. I didn't know what they were meaning, but are they essentially saying that as long as they dig more than 100 feet, then they have the rights there? So
yeah, let me explain. So just think of your sandcastle, right? If you're on the beach and you make a sandcastle and you start digging directly below it, the castle's going to crumble. But let's say you have like an excavation truck, right? And let's say like you dug 30 feet away, you kind of tunneled underneath it. There's enough support to keep your castle standing up. The same way, it's like if you ever go to a big city, there are subways that go underneath skyscrapers, but there has to be a certain number of feet of just dirt between the skyscraper and the subway tunnel. Otherwise, if you build the subway tunnel right underneath the building, the thing will just collapse.
So would that affect your numerator and denominator?
Yeah. So I'm using acres generally, but the correct measure is volume, how many cubic feet. So you count down how many cubic feet you have to dig. I'm keeping it a little bit simpler, but this is just, yeah. Yes, sir.
So to clarify, Holmes' the majority is looking at not at the land as a total. They're looking at it not as a whole parcel, but the dissent is saying as the whole parcel.
Yeah.
And you're saying that's why they won the day to get the transfer pension.
Yeah. So look, and I think Tyler stated it very well. Holmes' opinion has never been overturned. Don't get me wrong; it's still good law. But the Brandeis concept in the dissent, that you look at the entire parcel, that is more or less what Brennan adopts in the Penn Central case. He says you can't just look at the air rights by itself. You have to look at the entirety of the air rights plus the train station, right? You can't just look at the 5 acres you're at risk of losing. You have to look at the entire 100 acres in the contract. That's Chester's point, right? The entirety of the business arrangement, right? And what happens if this guy had 1,000 acres in the county, and you only lost 5 acres for drilling, for mining? Oops. Sorry. Decline. Right? And you lost 1,000 acres for drilling. No one wants me to teach today. It's a distraction, right? Fortunately, the game didn't go to 11 innings last night, so we got a decent night's sleep. Jesse.
It seems like that's mostly like a physical space analysis, but I mean, some businesses have a huge profit margin, some have a very little profit margin. So even if it's a 10% loss of their physical space, don't they look at when it was purchased, what they reasonably expected to profit through?
Whoa, you just reasonably expect. Where'd you get that from?
That's part of the Penn analysis.
Yes, sir. So we'll get to the reasonable expectations a little bit later. But to answer your question, if you haven't actually started building and pouring concrete, have you really made the investment yet? In other words, if you didn't start building this tower above, have you really invested any money in it? The short answer is blueprints are not enough to give you the expectations.
But if you're a company that raises funds and you're raising those funds...
We'll get there later, I promise. Penn Central's the trap you can't win. It's like the labyrinth, you're screwed, you're done. Once again, Penn Central, you're toast.
The other question I had is that here you have Penn Coal suing Mahoney, not the government, but the government submitting amicus based for Mahoney.
Right.
If they're suing for an injunction, then it's pretty much saying Mahoney can't restrict them from mining there, and the statute can't restrict them either.
Yeah.
But if they consider if they want damages instead, then they're not collecting that from Mahoney. Don't they actually have to sue the Commonwealth?
Well, yeah. They're not suing Pennsylvania for a takings claim. They just want an injunction to bar the statute, right? In other words, Pennsylvania is not going to pay up. If Pennsylvania was actually forced to go through the condemnation proceeding, they would just skip it because they can't afford it. What the coal company wanted in this case was an injunction, an order saying, don't enforce the statute, let me drill, or let me dig.
That's why they're suing Mahoney.
Exactly.
And
bingo. They want to dig, right? And they're suing for an injunction to block Mahoney from stopping their drilling. Instead of drilling, digging, whatever you would pull. I keep thinking of Zoolander with the coal mine. Questions on this one, the majority? Yeah, David.
In the Horn case, the racing case, what if and I'm not a farmer, so this might be very unrealistic, but what if they instead of saying, you have to give us, so many races, what if they restricted like, the acreage for raising.
Well, there's a case you said in common law with exactly those facts. You know the case. Come on.
The one about wheat.
What was it called? Don't break my heart, guys. What was the name of the case? Robert Jackson opinion. Oh, so close. I'll give it to you. Wicker v. Filburn. Very good. And in Wicker, the court held that under Congress's commerce powers, they can restrict how much acreage used to grow wheat. So one of the oddities of the raising case is they can tell you don't grow wheat, but if they let you grow it, they can't take it away from you. So maybe the government just says don't grow it in the first place. That's an oddity that the dissent raised in the Horn case. So any questions from the majority, right? Holmes's test is his diminution in value, but he looks in a very narrow sense. He's looking at what's taking away from you, right? What are you losing? That's the denominator. It's going to be 1/1. The dissent, though, I think had a much more influential effect in the long term, which often happens. I forgot where I am. Lindsay, you next?
Yeah.
Do you want to give us a dissent, please?
I think the dissent was just saying this was within the police power of the state,
Okay.
and they're basically just regulating a nuisance, so that this would not be a taking under the nuisance.
Very good. Now, does Justice Brandeis think that this is a very unfair law for the coal company? It's just like, does this disadvantage the coal company in an unfair way?
No, because they can go mine elsewhere.
But what are, let me ask the question a little differently. Are there any benefits to the coal company from this sort of regulation?
Benefits to coal companies in this regulation?
Yeah.
I don't remember saying anything that talks about that.
Robert, you want to take a stab at that?
Yeah, I'm not sure.
Anyone take a stab? Yes, ma'am.
I think after the case, they were saying that the coal company was already.
That's true. That's true. But I'm saying, is there what's called a reciprocity of benefit, right? Is there actually some benefit here to the coal company? Yes, Mom? Yeah. Good. Anyone else want to add something? Yeah. On the same track that Simone began, you don't want to live in a state where the ground randomly caves in, right? That's very dangerous. Worker safety, etc. So if Brandeis is saying, look, you can't look at this in such a narrow fashion, right? It's true. In those 5 acres, they won't be able to dig for coal. But in the big picture, right, the grand scheme of things, there's a benefit to everyone on the block that you're not going to have ground caving in at all junctures. Okay? So this is what's called this reciprocity of advantage, right? There's a benefit to the community at large, and probably a benefit also for the defendant. I'm sorry, in this case, the plaintiff, the coal miners. Okay.
What did you call it? Reciprocity.
Yeah, I'll type it up here for you. It's called reciprocity of advantage, right? Where all land use benefits and burdens someone, right? Any kind of a zoning ordinance, some people will be burdened, and some people are going to benefit from it. But this regime, on the whole, creates a benefit for everyone, an advantage for everyone. Okay? Because even though you may not like the fact that your land is not mineable, you're now having safety net that flows from that. And think of like zoning, for example. You may not like that you can't build a commercial facility in a residential neighborhood, but you get the benefit of having the quiet of a residential neighborhood. So with these sorts of laws, there's burdens and there's benefits. They're reciprocal arrangements. So Brandeis' dissent focuses a lot on this reciprocity of advantage, that this is not a law singling out any one person, it benefits the community as a whole. And also Brandeis says we need the right denominator. We need to look at the parcel as a whole. You can't just look at the specific area where the regulation is being diminished in value. Okay. Also, I want to give you this Latin phrase, which I think Tyler mentioned before. The full phrase is "Quis est solum," I'm going to screw this up, "eis est usque ad coelum et ad Tdrs," which means, for whoever owns the soil, it is theirs, all the way up to heaven and down to hell. And this is the common law doctrine that when you own a piece of land, Blackacre, you have not only the subsurface rights, but also the air rights. This doctrine has a lot of difficulty in the age of airplanes, right? Because you now have people flying through airspace, which is why Tyler brought the Cosby case. I don't know how much juice that case has left, so I wouldn't put too much weight in it. Yes, sir.
I don't know if this is premature, but as far as the application for the test, you said the majority is still good law, but you also said the dissent is best for long term. So how do we actually apply a case that would apply to these facts?
Oh, what a beautiful question. It's a good question. You have to know, with the Supreme Court in general, I'll just make a general point and answer your question with the exam. The Supreme Court doesn't like overturning its precedents. They don't like doing it because it looks bad. It's like, wow, these justices said one thing and now to a new 5 people say something else. So what they'll often do is they'll often distinguish them, maybe read them narrowly, or in the case of Penn Central, ignore them. Penn Central basically ignores these older precedents. The later in time controls. So what I'm telling you is that Penn Central is the rule, notwithstanding Cosby. But it gets more, right? So Penn Central is what, 1978, 79, whatever, right? We'll be doing Lucas, Tahoe, and Wisconsin v. Murr next week with Justice Busby. Those cases, in many respects, not modify Penn Central, but tweak it a little bit. So you have to know all these cases now to interact. I know that's not a good answer to you. I know you're hating yourself. No, it's a beautiful question, but a grotesque answer. But the short answer is the Supreme Court's takings doctrine is incoherent. And it hasn't done a very good job of reconciling the old and the new. It hasn't. So I'm going to try to walk through it as cleanly and as neatly as possible while being honest with you when things don't line up. Okay? Yes, Sir John Paul.
Could it possibly be because in this situation, this is in 1922,
Yeah.
they really didn't have the capability of understanding how much of that coal was on that specific project. So in that situation, we don't have the seismic exploration ability to, specifically in this situation, to understand how much of their profits will be lost. Then we apply the majority, but we can instead of applying consent.
Well, under Justice Holmes, they lost 100%, right? But what you're saying is they may not even know if there's coal in this part or coal in this part. They didn't have the proper exploration. So this is probably an easier test to apply. When we get to something like Penn Central, which is in a few minutes, you know with certainty that how much money you can build, how much money you can make by building a tower of so many floors, right? If you build a 50-story tower, it's X dollars. If you build a 30-story tower, it's Y dollars, right? So there's a lot more certainty. And that's why I think the Penn Central test gives a little more juice to what Justice Holmes is saying. So let me use John Paul's question to segue. What Justice Brennan did in Penn Central is basically he took Justice Holmes' test, this diminution of value, but he applied it to Justice Brandeis's denominator, right? I said it again. He took the goes too far test and made it a little bit more rigorous, but did it under Justice Brandeis's partial as a whole rule. So Penn Central is like a Frankenstein, right? It basically merges Holmes and Brandeis into like one opinion. So to Justin's question, Holmes' opinion is good law because the Penn Central case takes part of it. And I'm going to tell you Brandeis thinks good law also because Brennan takes part of that as well. So there you go. Any questions more on Penn Central before we move on? I'm sorry, Penn Cole. Okay. All right. Let's talk about Penn Central. Who's next? Robert. Yes, sir. Okay, I appreciate your hand raising. You want to give us the facts here, please?
Sure. So there is New York's landmarks preservation law, which put restrictions on property that was designated as landmarks. Then New York designated Penn Central Station as a landmark. So the owners, it put restrictions on the owners' plans on building, offices on top of the station. They offered 2 different proposals, but they were both denied. The owners then sued when this was a take. the trial court granted an injunction. The Supreme Court, appellate court, I think that's the state.
Exactly. Oh, someone's paying attention. Very good. Yeah. In New York, the Supreme Court is a trial court, and the New York Court of Appeals is the highest court in the state. Very good.
They reversed it, saying
Good.
that the restrictions were necessary to promote legitimate public purpose of protecting landmarks, and then it went up to the Supreme Court.
Very good.
They affirmed.
All right. So let's just explain some of the similarities and differences between the New York law and some laws we've discussed in the past. We discussed in Village of Euclid, right? There was a zoning code that applied to the entire city. And that if you were in Zone 1, you could build one-family houses. If you were in Zone 2, you build two-family houses. New York had a zoning code, right? And that wasn't being challenged here. Instead, they challenged this preservation law that did something different. It did not apply uniformly across the city. It applied to specific pieces of property or specific blocks. So I think there were 400 some odd buildings in New York, whatever the number was, right? Basically things that were deemed historical and that the city did not want to be changed. This law did not make it impossible to change historical buildings, but it made it really, really, really hard. I think Robert went through a couple of the standards. You basically have to go to a board, these preservation boards, and you can ask for what's called a certificate of no effect, which says, I want to make a change that will not affect any architectural features. That's got to be something minor, right? You know, installing a new bathroom inside, right? You know, changing the carpeting, maybe. But if you want to change the facade, the outside, you're toast. What these laws require is that the outside basically remains identical, right? Even like if a new company buys your building and you want to change the name on the sign, like you're gonna have a difficulty even doing that. The second process was called a certificate of appropriateness, which says, yeah, we're going to, you know, make a change, but it's appropriate. Okay, good luck with that. It may be denied if it diminishes the use of the landmark. And there's also a third one, which I don't think is implicated here, where if you're getting insufficient return, that is, because of the landmark status, you're losing a lot of money, you can ask for permission to make some changes. I can cut to the chase. Landmark preservation laws mean you can't change your property. And once your property is so designated, you're stuck. Yes, Yusuf?
Well, then back to my question, why would you designate something as a landmark? What are the benefits?
It's involuntary.
Involuntary, okay.
Do you think Penn Central wants their building designated as a landmark? Do you think any business wants this? No, it's a death sentence, right? Right? Once you get that plaque on your wall saying landmark, wow, that's great. No. It means you're not going to sell that land ever. It means that you can't really build on it. You can't make improvements without going through some board and persuading them that it's not going to make a change. So, Yusuf, your question is very appropriate. It's involuntary. They designate you as landmark. It's not like, and you can't really challenge that in court and you can file a lawsuit as they did here, but you're going to probably lose. So, the long and short of it is, once your property is designated as this landmark status, you're stuck. And your ability to make changes is diminished. Any rate of return for selling it is probably diminished as well. There's one wrinkle though. Kaylee, you want to tell us about these TDRs, these transfer development rights? What are those about?
So basically you transfer your right to develop on your land and basically give you the right to develop on another property what you otherwise are unable to do on your own property that has been deemed.
Yeah, so this is like a weird thing, and this is like, you know, New York, it's a, so let me put this picture, I like this graphic. In New York, you need a permit to build just about anything, right? You need a permit to build anything. And so let's say in theory, on top of the train station, you can build a 50-story tower. But because you've been designated as a landmark, you can't build a 50-story tower there. What you can effectively do is sell your air rights to someone else in another building, maybe a couple blocks away. They could not build a 50-story tower, but you're basically transferring your air rights to them. that makes sense. So New York gives you a almost like a credit where you can profit by selling your air right to someone else. And in fact, in this case, were people who wanted to buy those. So, going back to the question I asked at the outset, did this regime actually extinguish all the air rights? In a literal sense, yes, but in a financial sense, no, because they could sell it somewhere else. Now, how much money will you make from selling the air rights versus building your own 50-story tower? Oh, come on, right? You make a lot more money by building your own tower than by just giving the air rights to someone else. Also, negotiating with someone in this case is going to be a little bit difficult because you have no choice, right? You either sell your air rights or you don't. You can't hold on to them. They have no value otherwise. So you get a much less rate of return. But in theory, at least, you could sell your rights somewhere else. Yes, so Jesse?
You saying you can sell rights that you have no right to do anything with to someone else?
Yes.
Still have no right to do anything with it?
The other person's not designated as a landmark, though. So you sell your air rights to a building that's not designated as landmark, and they can build a tower there.
They can build a tower
A few blocks away. No, not your parcel, on their parcel. You understand? So let's say there's like a few blocks away, there's like a small, apartment building that's 5 stories tall. Generally, that building would not be allowed to build a tower on top of it. There's not zoned for it. But the city says, okay, we'll let you do it because we're selling out your air rights.
Without having to take that to the zoning board and them saying, well, we don't want this here either?
Of course, and then the zoning board can block it as well, which is why these things are illusory, right? That's why I say Penn Central is a trap, right? In New York City, you can try to sell the zoning rights, the air rights to someone else, but there's no guarantee the zoning board lets the other person build. So it's a trap. You're gonna win.
So if that person, the second person, wanted to build, why wouldn't they just go to the zoning board and try to purchase those rights?
So when I say zoning board, generally in certain places there might be a fixed limit saying you can't go above, say, 5 stories. But by getting this TDR, you're allowed to go above 5 stories. But the zoning board can still deny it because of shadows and traffic and other things. So what I'm saying is, even if you get the air rights, and you're allowed to build in theory, they may just deny the construction because of traffic, noise, shadows, anything else. Building in New York is virtually impossible. It doesn't work. It's very difficult. But the TDRs can be used. I mean, they are sold, and people do make them work, but there's no guarantee. Which is why when you're buying a TDR, you may not give that much money. Okay. So with me so far. Yeah, Bradley, yes, sir.
Do you have any idea how much something like that would go for?
Oh, I don't know. You could probably Google it. I know there's been a couple of TDRs in recent years that have been sold. There's actually a case in your book that I don't teach anymore. It's too complicated. But involves a New York City transfer development rights. It's the Giuliani case. It's in your book. Go read it if you want. I don't teach it anymore. But it does discuss the value of a TDR a little bit. There's a reason why I don't teach it. I taught it once or twice and it was just hated, so I gave up on it. It's in your book. All right, so any questions on the facts? So, there are 2 issues then from Justice Brennan, right? 2 issues. The first issue, is this a taking? And the second issue is, if it's a taking, are these TDRs, these transfer credits, just compensation? Basically what New York's saying is, okay, even if we're taking your property, we'll give you this valuable thing instead. It's not what you want, but, the court doesn't reach number 2. The court doesn't reach the question of compensation because they find that there's no taking. Okay? And then we get Justice Brennan being Justice Brennan. He was the master at this, where he would synthesize all these various pieces of case law in a way that sort of makes sense but doesn't. And so he throws out several factors. Okay? Again, what he's doing here is trying to give meat to Justice Holmes. What Brennan is trying to do is trying to give the diminution and value test some rigor to it. So he identifies 3 factors. Okay? 3 factors. I'm going to write these out for you. The first factor is the extent to which the regulation has interfered with distinctive investment-backed expectations. Distinctive. That's right, distinct. Distinctive is not a word. with distinct investment-backed expectations, or call them DIBs if you want to be cool. No, not cool, I don't know. The extent to which the regulation has interfered with distinct investment-backed expectations. I think, Cody, you're next. Cody, what on earth does that mean? It's a very important phrase, which Brennan basically doesn't even discuss at all. But give me your sense. What's he talking about there?
If investors expected something, put their money and their resources into an idea, and does this regulation basically take that away, whatever they were investing in?
Okay, good. Now, we know what investment means, but what's a distinct investment-backed expectation? Try and give me a little bit more on what they're talking about.
I'm really not.
Yeah, me neither. I've been teaching this for years. David, do you want to take a stab here?
Well, I might be wrong. Like I was saying, like if there's a way they could, maybe not to certainty, but like just a certain degree, predict like how much financially is being gained or lost.
Okay.
Is that kind of like a?
Let's try this, right? So we know that Penn Central hired an architect, right? They developed some blueprints, different schematics, different ways to do it. How much money have they invested in building this tower, David?
Well, all they said blueprints don't count.
You're listening, good. So have there been investments in this project?
Well, no. I mean,
A little bit.
if you don't, huh?
A little bit, right?
Well, a little bit, but I mean, like, it's just blueprints.
Okay, so everyone see what David's getting at, right? Under the majority analysis, it's not enough to just expect a rate of return. You have to have distinct or clear investments in that return. But herein lies the trap. It's a chicken and egg problem, right? You can't start pouring concrete till you have the paperwork, till you have the permits, right? But you don't get the permits unless you have the investment-backed expectations. So how can you ever have distinct investment-backed expectations when you can't start building yet? If you already have maybe the coal mine, think of the coal mine, they were already drilling, right? They've been there for a while. Why? The statute, the Kohler Act, came after the drilling began. So if you're already doing something and the government tries to get you to stop, you can show investment-backed expectations, right? If you already have the thing there and they try to say stop that or tear it down, you can show investment-backed expectations. But here, all they have is pretty pictures, right? Maybe they have like a real estate deal lined up, but the expectations are not backed by investments, right? That's the way to read this sentence. Let me say it to you again, right? The expectations are not backed up by investments. You're expecting some money, but you haven't invested enough in it yet. Okay? One second. I'll get both of you in a second. What Brennan's trying to do here is make homes some sense, right? Instead of just looking at the diminution in value, how much money you're losing, right? The better question is, did you expect to make profits? Did you invest to that? And if so, are you not getting them? I think, okay, so Kayla, your hand was up a couple minutes ago, and I'm doing order.
Yeah, so one of the notes following the case states that some courts have read this to mean that the expectations are frustrated only when the land use regulation denies all economically viable use of land. Is that something that we should adopt when interpreting this?
You'll do a case for next class called Tahoe Sierra that more or less adopts that rule. So that isn't necessarily following from Penn Central, but the Tahoe Sierra case has adopted that rule. So yeah, the short answer is yes, that's correct. Cody, I think your hand was up as well?
And I'm not a fan of hypotheticals, but I am curious.
That's fine. I'll take one.
Should, say the investors buy the materials? They haven't begun laying the concrete.
Use materials somewhere else. Build it somewhere else, right? See, I'm fighting your hypo. You don't like when I do it either. But the point is, the standard that Brennan's putting here virtually makes it impossible to win a takings case. Right? If you're already doing something and you have expectations for profits that are backed by solid investment, you have a shot. But if you're trying to build something new where it hasn't been anything before, you're probably going to lose. Justin, you have something as well?
Yeah, I mean, I know it gets much of what you just said, but like even the UGP promising to pay the million for the...
You think that'd be enough, wouldn't you?
Yeah.
Right, how many millions was it?
Well, they initially did 1 million, but up to the 3 million annually thereafter. Like, those promises weren't...
Now, was that contract probably contingent on getting zoning permits, right?
Yeah, the landmark deal, so they already...
So, look, even your own contract wasn't expecting this to go forward unless you got the paperwork approved. So, look, if you're a developer in New York City, right, you're not that dumb to put $1 million on paper unless you know it's contingent on this paperwork coming through. So the court said, look, if you actually invested a couple $1 million in this, maybe we'll take you more seriously. Come on, right? No one's gonna go to a bank and we'd like a $50 million loan for something that may never happen. You're not gonna waste your time with that.
Then it goes back to the harsh, involuntary landmark placing on
That's Yusuf's question, right? Yeah. It's involuntary, right? It's probably Penn Central for years of, look, we're going to raise all this money, build this 50-story tower, and then boom, they get hit with this. Now, let me go back to the picture, and I mentioned this earlier. The reason why this came up was because of the construction of this building. It used to be called the Pan Am building, now it's the MetLife building. If you ever saw the movie The Aviator, remember Alec Baldwin played, what's his name, Juan Tripp, who's the head of Pan Am. He's an office in the very top floor of the, anyway, it's that building. So they build this building overlooking the train station, and people are like, oh no, we don't want to we don't want to lose this beautiful view. But as it was, the view was destroyed by this building, right? You already blocked the view going downtown. Yes, sir, Jesse.
So if a different company purchased Penn Central Station, and let's say Penn Central had a value of $50 million based on what it has done in the past, and it doesn't have restricted zoning, but I'm paying, instead of $50 million, I'm paying $1 billion because I'm going to build a massive skyscraper there in Southern Ranch. Yeah. Even though I haven't started building anything, if it was reasonable at the time of purchase to think I could build that structure, does that count as investment, reasonable investment back? Expectations, even though I haven't built anything, but I just...
Yeah, I think it'd be an idiotic business transaction, but I think it would help your case. I think you'd still lose, but I think it would help your case. Right? I mean, Jesse's question, just to repeat it, is what if you actually spent $1 billion to lay the groundwork to build this tower because your expectations were you were going to return based on this high thing? That would, I think, make a different story. But generally in business, you're not going to invest money in something without the permitting in place. Right? This diminishes the value, but the court says not by law. Okay, so that's the first factor. The second factor, a little bit more nebulous, okay, is the character of the government action. This one doesn't play too big of a role, but what exactly is the government doing? They're trying to preserve beauty and aesthetics and the appearance of neighborhoods. And that's something that's traditionally within the police power, right? They're not doing something bizarre or something novel. They're trying to make things look a certain way. So the character of the governmental action is not very problematic. The third factor is Loretto. Now, Loretto hadn't been decided yet. It was decided a few years later, but Loretto now will make more sense. It questions whether there is a physical invasion, right? Okay? This makes Loretto a little bit more sensible, right? That if there's a physical invasion of some sort, it's more likely to be a taking. Now, we talked to Loretto as this categorical rule. They didn't quite adopt that yet. That came a couple of years afterwards. But let me tell you, my friends, the only factor that really matters is number one, right? That's where all the litigation transpires. Do you have these DIBIs, these distinct investment-backed expectations? All right. Now, Nicole, when we're calculating the investment and the expectations for return, are we limiting ourselves only to the air rights above the property? We're calculating how to actually get rid of it. Are we only considering the air rights?
The court here considered more factors than just that.
What are they looking at? Not just the air rights, but what's that phrase in the Brandeis dissent? We call that. Not what's her name. I'm mothering it here for us. Let's let her get the answer. What does Brandeis call this?
Reciprocity of Advantage.
Oh, you get the other one. The other, he mentioned the other thing. Casey. Tyler, what's that phrase that Brandeis uses in dissent?
I'm not sure. I've never written down.
The mother is. That's it.
Is it that if you look at it as a parcel?
That's what I'm looking for now. Back to Casey. The parcel as a whole, right? The parcel as a whole, right? So, what's important to remember here is if they had actually applied the Holmes approach, you'd say, look, the air rights are so many feet. They're taking all those feet, 100%. But instead saying, look, we're not just looking at the 50 stories above the building. The train station's there. It's profitable. It makes a profit, right? And because you still have these other returns on your investment, as a balance, you lose. So again, the court embraces Holmes' diminution and value test, rephrasing it as Divi, right? The diminution and value test is basically morphed into this distinct investment-backed expectations. But when they talk about the denominator, they use the Brandeis, right? They look at the parcel as the whole and not just the 5 acres we got here, or the 50 stories we have here. Okay? Okay. All right, so any questions so far? Any questions so far? Lindsay, your hand up, or you just...
Oh, no, but I guess I kind of do. Like, Crosby isn't good law, but all they were doing was invading the airspace. But I thought that also the invasion of the airspace was so severe that they weren't able to use the land as a chicken farm anymore. So, like, this is distinguishable from this case where they can use the train station still.
So there are cases, right, where people live near airports, and they try to bring these sorts of takings claims and they lose. So when I say it's not good law, maybe you can distinguish it. The FAA has created a fairly rigorous process. The FAA has created a process where if there's noise by an airport, you can complain to an administrative process. So today, if you have problems with airplanes flyover, you have to go to a administrative board. And I'll give you an example. This happened to me once. Everyone know Reagan Airport, DC National, it's right near Washington, DC. It's right near a residential community. After a certain hour, I think it's either 9 or 10 o'clock, they can't have too much noise. So I was once in a flight from Miami to DC, and it got delayed by an hour. And had they landed at that time, it would have been too late, it would make too much noise. So you know what they had to do to decrease the noise? They had to decrease the weight of the plane. And they kicked like 10 people off the flight and their baggage so the plane will be lighter and will make less noise. Seriously. So the problem of flyover is more or less governed now by FAA regulation. It's a Federal Aviation Administration, not the Fifth Amendment takings claim. But at first they were saying, okay, we'll give you a bonus, we'll give you a voucher, we'll give you a hotel. And after all, I was like, we're going to throw people off this plane. And they basically take what's lowest status. I was okay. Frequent flying comes in handy sometimes. But to answer your question, you don't have taking claims for planes bothering chickens. It just doesn't really happen anymore. So when you buy, so if you may not try. I didn't travel much in law school. But when you buy a ticket, there are various ticket classes, right? Depending how much you pay for it and when you buy it, and they can actually rank you on the flight. So every there's like an upgrade list and a standby list. You're sorted based on your priority. So basically, people who bought the cheapest tickets, the non-refundable tickets at the end, people flying standby, they got bumped. They were not happy. But literally, the reason why they had to bump people off was to decrease the weight of the plane. and take off their luggage as well. Because every person, say it's 200 pounds plus another 50 pounds of baggage, right? Whatever it is, you kick off 2 people, 10 people, it's like 2,000 pounds. So it does add up. I had not had that happen before, but you fly a lot, you see the craziest things. I've gotten downgraded in business class to coach. That burns. A couple times because my seat broke in business class, I did kick back. And once because there was some VIP who took my seat in business class. I don't know who it was. They board at the very end. They don't tell you who they are. Anyway. So let's go back to Penn Central. Okay. The court concludes that this is not a taking, right? The restrictions promote the general welfare, and they also give Penn Central an opportunity to enhance the site and make the profits in other fashions, such as by selling their Tdrs. Okay? In other words, they're still getting back returns on their investments. The investments they haven't made yet, well, they haven't made them yet, so they don't get a profit on that. So any questions in the majority? Casey, to you. What's Justice Rehnquist's dissent here?
They talk about how basically the laws are putting all of the burdens on people that are restricted, and that's not right.
Yeah.
That they should have to maintain their property for being forced to have regular life.
How would Justice Rehnquist measure the denominator here? Would he only look at the air rights, or would he look at the community as a whole, this average reciprocity advantage?
Well, they think that the whole state should.
Yeah, right. So what Rehnquist is basically saying here is, this is not in any sense benefiting Penn Central. It's giving a benefit for certain to the neighborhood, but the costs are falling entirely on one company. And this isn't like the coal case where you don't want the ground randomly caving in throughout the state. It's specific pieces of property, right? So if you're on this block, you can't build a skyscraper. If you're across the street, you can. Is there any difference for the people of New York whether this block or that block is a skyscraper? Maybe for aesthetics, but the burden is being concentrated on a very small percentage of buildings. So general benefit, concentrating the cost. Okay. As a result, Justice Rehnquist would say compensation is required. And he says there's no indication that these Tdrs, this is Jesse's question, how much are they worth, right? There's no indication these Tdrs are worth it. You need a proceeding from a judge to determine if it's appropriate. But that was merely the dissent, and these landmark laws exist all over the country. And as Yusuf suggested, if your building is designated as a landmark, it's involuntary, you've lost a lot of money because you're not going to be able to sell it as well. You can't improve upon it. You're stuck. Even like, Houston, the Astrodome, right? There's certain historical status on the Astrodome that makes it harder to demolish. That's why it's still there, vacant, empty, can't really touch it. Did anyone see a couple of years ago they blew up the stairs? Anyone watch that? There used to be these the ramp stairs outside. I actually watched it get imploded. It was pretty cool. I almost missed it until it was on my phone. It blew up. I was like, damn it, but I saw most of it. But you have difficulty changing these historical sites. Okay? So now let me try to start giving you a framework for this all to make sense. Okay? Right? There are a series of questions you should be asking yourselves with these sorts of takings issues. Right? So is there a permanent physical occupation? This is Loretto, right? And if the answer is yes, you got a taking. You need compensation. That's easy. If you have a permanent physical occupation, you're good. You're Loretto. Okay. Now, if no, you go to Penn Central, right? You start applying the Penn Central test. And you have to keep in mind several things, right? Does it concern a nuisance? Then you're in how to check. Right? The baking of the bricks was a nuisance. If it's a nuisance, you're in how to check. And there's no taking. It's police power. Okay? If it's just general zoning, whatever, then you apply the Penn Central test and look for your divvies. Okay? This is what I mean when I say there'd be 5 or 6 cases you have to walk your way through. So if you're going to take these questions on the exam, you have to ask yourself, do we have here physical occupation? Yes, no? Okay. If it's something else, you say, oh, there's a nuisance, right? They're trying to stop smoke, bricks, whatever it is. Had to check. If there's not a nuisance, you go down to Penn Central land and look for your divvies. This will get even more complicated with the case you'll read for Justice Busby on Tuesday. Please be prepared, don't embarrass me. You guys are good, but he's taking a lot of time out of his busy day to come here and give you a lecture, so be prepared. But what we have here is the beginning of the sorts of cases you have to consider. It's actually not that hard here. It gets a lot worse next class because the court screws up Penn Central with one opinion by Justice Scalia in Lucas, another opinion by Justice Stevens in Tahoe Sierra. And to preempt your question, Justice Stevens' opinion more or less overturned Scalia's opinion without saying it, weakened it significantly. Any questions for you? Any questions for you? I look forward to seeing some of you more for exam reviews. So far, so good. You guys are doing well. I will see you tonight. Thank you. That's fine. Yeah, well, as long as you have